Good morning, everyone. Welcome to the Learning Circle webinar today. So today's session is part two for wills and estates for Indigenous people, and today's focus is for on reserve. And if you missed part one, the video is up on our website, and we'll put a link in the chat for that. But part one was for off reserve and non-status. So really pleased to be here today to facilitate this really important conversation. This conversation is supported today by the Center for Excellence in Indigenous Health and generously funded by the First Nations Health Authority. But before we begin, I just want to acknowledge the traditional lands that we are all calling in from. We're all calling in from various places across BC, across Canada, and some across the world. So just acknowledging all the traditional lands that we are on, the ancestors, the animals, the birds, the water, the trees, the stones. For those of you that don't know me, my name is Melanie Rivers. I'm from the Squamish First Nation. I'm also of Scottish ancestry from the Forbes clan, and my ancestral name is Tieltawit, and I am filling in for Seraine this week. I also work at the Center for Excellence in Indigenous Health on the Indigenous Health Administration and Leadership Program. So I'm really pleased to be here today to step in and facilitate this. So also in the background is Cynthia, our productions coordinator. She'll be interacting with you in the chat and making sure all our tech is working well. So thank you to Cynthia. And just before we begin today, just a reminder that some of the Learning Circle's topics can be emotional or activating, and just to look after yourself. If you need to talk to a friend or an elder or a counselor, please do so. And we'll also put some resources in the chat as well. And today's topic as well is it's on wills and estates, so also one that can be a bit emotional for us all. And I just also want to say today's session a little bit different than most of the learning circles in that we won't have a Q&A session at the end, and that's or throughout, and that is due to the legal nature of the information. And there's a lot of complex information for our guests to cover, and they did an amazing job in part one, going over this information in a really respectful way, in a really clear way. So looking forward to today's session as well. So I will turn it over to Wichita in a moment to open us up in a good way. And then after he opens our session, Catherine and Chris will jump in with their presentations. So, Wichita.
Am Hoitach, Tialtawit and Hots and Stomoch, Siam and Ci, Quichtal, Koshaman and Skotmasho Humeo, Amaltasin O Humeo, Tumakwitsi Quitsnachum. Quichtal's my ancestral name. Dennis Joseph is my given name. I am grateful and thankful to be here and bring warm greetings from Hamaltasin Village, one of our Squamish villages here. Hamaltasin is also known as Keplano IR number 5, also known as part of West Vancouver. I want to, in a moment, share a blessing with all of the presenters, all of those witnessing the work that we're going to share. And I just quickly wanted to offer a traditional perspective. The third generation to be speaking this language, English. And I am fortunate, along with my niece and other relatives online, to have grown up with aunties, uncles, grandparents, great-grandparents, especially the greats and the grandparents, who were often born in a log house or indeed a longhouse, and they passed on many sacred teachings. And when we come from that to issues like we are dealing with today, there's often conflict. But I want to hearken on a teaching, at least from here, and what I've learned from our elders from this part of the world, is to always be kind and to always be gentle. And I want to share with you a song that actually comes from my heart to yours, witnessing and presenting. The first word in Squamish acknowledges the Creator, Chasiam. The second word is Chisho, acknowledges Mother Earth. And the third word is Seisei, which is all of our relatives. I heard from my great-grandparents and others that we are all connected one way or another, no matter what language we speak. And man is the last word in this song, acknowledges all of our children. And the word throughout you'll hear is Anina. Growing up in the middle of 11 kids, I heard that word a lot when one of us fell. And when that happened as a toddler, and even in my adult life, I heard it a lot. As I got a bit older, I asked my mother, what does it mean? And she shared this. You're going to fall in life. It's up to you to get up, and you better get up. But every once in a while, you're going to need some help. And this word, Anina, is to keep one's soul, one's spirit together. Because if you're separated too long from your body, that's how one gets sick. So blessings for you all. I wanted to ease into it in a gentle way for all of us witnessing here today and sharing. Anina. And I'm going to do it a cappella. I understand the drum has a bit of, background noise, so I'm going to do my best to go a cappella. Osiam, invite you all to share in your own way. Anino. 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 Chisha, chisha, okume, anino, anino. Say, 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 Anino, Anino. Man, 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 man. Wojciech Chasiam, Skakostomo, Svinaslani, and Sese. Tumakwitsikutsnacham. Blessings for the work today, and also acknowledge our families on this side of the water, as our elders say. We indeed have had a loss in our community, a dear elder. And for any of you who've had a loss recently, blessings for you. And again, for all the work today. Osiam, Wojciech. Thank you.
Thank you so much, Wetzel. I am Catherine Schlenker. I'm one of the presenters today. Before we get started, I'd like to acknowledge with both respect and gratitude that Chris and I are joining you from the unceded traditional territories of the Lekwungen people, today known as the Songhees and Esquimalt Nations. I'm thrilled to see people introducing themselves in the chats, so thank you, Melanie, for encouraging that. I'd also like to thank Melanie, Cynthia, and Serene for getting this all up and running through UBC's Learning Circle, as well as Sue Bartnett from the First Nation Health Authority for bringing us together. This is our second presentation, and so while we will cover briefly a little overview of some of the topics in the last presentation, if you're left with any questions, I would encourage you to review that prior recording as well. I am a citizen of the Métis Nation. I have mixed European and Muskego Cree ancestry. I'm a lawyer and a program manager for Seniors First BC, which is a charitable nonprofit organization serving older adults across BC with various issues affecting their well-being. In particular, my practice focuses on offering free wills, powers of attorney, and representation agreements to older adults of limited means. And we do that through established remote clinics in Nanaimo, Prince George, Chilliwack, Williams Lake, Skidegate, Masset, and Seashelt currently. We also do ad hoc clinics, and my team has the unique privilege of spending quite a bit of time working in community, thanks to funding through both the Law Foundation of BC and Indigenous Services Canada. It's my honor to be in a position to help the old ones and elders prepare the documents that we're going to be talking about today. I will pass it over to Chris to introduce himself.
Thanks, Catherine. Hi, everyone. My name is Chris Hesslinga. My pronouns are he, him, his. I'm the director of the Law Center, which is a student legal clinic in downtown Victoria, run through the University of Victoria Faculty of Law. Our clinic provides free legal services to folks who meet our income criteria in the greater Victoria area. And we do our intakes currently at our downtown offices, as well as doing some intakes currently at the Victoria Native Friendship Center. We hope to be able to expand the places and communities we serve and do intakes at. Just by way of brief background, I'm a settler from European descent. My mother's family lived for many generations on the territory and lands of the Three Fires Confederacy, the Odawa, Potawatomi, and Ojibwe, also known as Southern Ontario. My father is from Holland and moved to Canada when he was an infant, lived in Treaty 1 territory in the heartland of the Métis people. And I grew up in the territory of the Mississauga and Anishinaabe, and spent the last 15 years on the territory of the Musqueam, Squamish, and Tsleil-Waututh peoples before just recently moving to the territory of the Lekwungen peoples. And I acknowledge all of that, and just by way of background for myself. And yeah, thank you to all the organizers, and especially to Elder Dennis for that incredible welcome and opening this morning. Really got to me, actually. So really, thank you so much for that.
So today we're going to be talking specifically about wills and estates for Indigenous people who are living on nation or reserve lands. I will move to the next slide. We're going to review the advanced planning documents generally, because I won't be touching in too much detail on anything other than the on reserve or on nation land wills today. Following that, we'll move into possessory interests in property. I know that none of you thought that you were signing up for a course on property law, but unfortunately it is a really important piece of doing the wills for those of you who have a home on reserve. And then we'll talk about the on reserve or on nation land wills. And we'll wrap up with some resources and referrals. You go to the next slide. We've already done acknowledgements, but on behalf of both Chris and I would also like to acknowledge the Indigenous legal orders of the Lekwungen and the Saanich people, whose territory we are living and working on, and their historical relationships with that land that continue to this day. Our focus on this presentation is going to be on the colonial legal system. That's not meant in any way to detract from the legitimacy of the Indigenous legal orders. And I'd like to acknowledge that the documents that we're going to be talking about, we understand are not the traditional way of expressing one's wishes, both in life or after death. However, it is the system, unfortunately, that exists and that we're working with. And so our hope is to educate as many people as possible on how to best express your wishes so that they are respected. Can we move on to the next? We've already done introductions, so I will skip over this slide. Thank you. And I'll pass it over to Chris.
Thanks, Catherine. So this is kind of a repeat slide from part one. And so if you want more details from this part of the presentation, please watch part one of our presentation. But this slide describes how there are a few different advanced planning options, and advanced planning is just a fancy way of saying, you can make certain documents that can plan for the future, a future where maybe you don't have the same level of mental functioning or capacity. And so while someone's alive, the advanced planning options or documents they can create to help manage their life and assets or things they own include a power of attorney document, a representation agreement document, and an advance directive document. For a complete description of each one, or maybe not complete, but for a lengthier description of each one of those documents, please watch part one of our presentation. After someone passes away, all of those documents that I just mentioned no longer have any effect. They no longer apply. So a power of attorney, representation agreement, and advance directive no longer apply when someone has passed away. The document that would apply would be their will. The slide also references a thing called a trust, and that's will not be covered in today's slides, as it's just a very complicated concept. In law school, there's a whole class dedicated to it, and it's one of the most complicated classes you can take in law school, so it's far too complicated for us to cover today. I apologize for that. I wish we could cover more. But yeah, so different documents exist for different times. While someone's alive, the documents listed there apply, and once someone passes away, it's their will that will apply. So just moving on to the next slide, the next concept, which again I cover in maybe a bit more detail in part one, is mental capacity, or you might hear us just refer to it as capacity in our presentation. And it refers to the ability to understand and appreciate the nature and consequences of one's decisions. And so that's a very complicated definition, and probably isn't even a perfect definition. It's a very complicated term that, I could probably have a whole presentation on, but you can kind of think of it as someone's ability to make decisions and understand their decisions, but it is a bit more complicated than that. when it comes to the capacity required to draft a will, at least, it specifically includes the need to understand your assets and liabilities, or understand what you own and what you owe other people. It is presumed to be had by all adults. You're presumed to have capacity unless it's established otherwise or proven otherwise, usually by a medical opinion or judge's decision. So you can think of it similar to in the criminal justice system. You're supposed to be presumed innocent until proven guilty. Within capacity designations, you're presumed to have capacity until proven otherwise. Mental capacity and the ability to understand and appreciate your decisions can change suddenly. And it can vary, like day to day, even vary from morning to afternoon. So it's not only a difficult concept to understand and think about, it's also a very difficult concept for people to apply and evaluate. I also want to take a brief moment to acknowledge and recognize that there are serious issues that exist with giving the power to make decisions over people's capacity almost exclusively to judges, lawyers, and doctors, as cultural misunderstandings and legitimate fears of these professionals can and does lead to incorrect decisions regarding someone's capacity. So, that's again just kind of touch on how this could be its very own presentation. There's lots to unpack and discuss with capacity. I'm just kind of doing my best to describe it for you today. And capacity is necessary for those in order to draft all the documents I referred to in the previous slide, the documents that are effective while you're alive, the power of attorney, representation agreements, and advance directives, as well as wills. And when you need to have capacity actually includes not only when you're giving instructions for the will, but also when you're signing the will. So it can certainly be a difficult thing when someone might be losing their capacity. Capacity also, you can think of it as existing on a spectrum. It's not a light switch that gets turned on and turned off. It changes gradually, or it can change suddenly, but it certainly exists on a spectrum where you can have a little, or you can have a lot, and you can be somewhere in between. But you need to have a certain level to be able to give instructions for a will and to sign a will. I'm ready for the next slide, and I'll turn it back over to Catherine.
Thanks, Chris. All right, so as I mentioned, I'm going to start with an overview of the possessory interests in nation lands or reserve lands. Before I really get going, I'd just like to touch on the fact that the language that I use may be sensitive for some people. I recognize that some of these words are potentially words that have been used to control or restrain people. So when I use words like executor or administrator, I do so acknowledging that those are colonial terms. You may also hear me refer to ISK. I tend to default to saying ISK. It is the shorthand for Indigenous Services Canada, which currently is the government ministry that is handling the estates. They have changed names over the years. They previously, I believe, were INAC, and then that split. You may also hear me refer to a nation as a band. I really don't mean to cause any offense. Many of the nations that I work with do prefer that language, so please recognize that if I do use the word band or nation, I'm intending to use those interchangeably without causing any offense. And the same goes for reserve land or nation lands. I recognize that different nations have different preferences, and I am trying to cover in the most respectful way everybody's interests. So the law applies on reserve or on nation lands, and that's different than the law that would apply elsewhere. So for somebody who is perhaps status but living ordinarily in Vancouver and working there, the law that's going to apply to their wills is called the Wills, Estates, and Succession Act. And Chris and I covered that in the last session. On reserve, the Indian Act applies. We also have some other things that apply. So the Framework Agreement on First Nation Land Management Act applies to lands. Not all nations will necessarily have taken the steps to be part of that. However, for those that have, the land codes, land use plans, and decisions of chief and council with respect to the use of lands will also be very, very relevant. And then also the Family Homes on Reserves and Matrimonial Interests or Rights Act. That one's a mouthful. And I will touch on that towards the end. Can we go to the next slide? All right, so first off, let's talk about ownership. Now, usually when I talk to clients in community, they have a home. They've lived in that home, let's say, for 30 years, and they view that as ownership. And I think that that's a fair assessment. However, technically, the law is that the land for nation lands and on reserve is actually owned by the Crown, but held for the benefit and use of a First Nation to hold as a community. That doesn't mean that there aren't, that an individual can't hold an interest in the land, or certainly in the buildings that are on it. But it does mean that that ownership is not the same type of ownership as we would see in off reserve or off nation lands. Can we go to the next slide? So the government, or ISK in particular, does play a role in how things are handled when it comes to wills. So one of them is approving transfers of CPs. You might see CP as a shorthand in some of these slides. That stands for Certificate of Possession, and that's one of the possessory interests that I'm going to talk about today. ISK also validates the wills. That includes approving executors named in wills and appointing administrators when somebody dies without a will. When no family is available, ISK will settle estates. They sometimes manage finances for people who can't due to incapacity, and they also will pay out trust accounts for minors when they come of age. Can we go to the next slide? So you may have thought that I glossed over what possessory interests are. Now, possessory interest is kind of another way of saying ownership, except it means that your ownership isn't the same as off reserve. So the highest level of possessory interest in land is a certificate of possession. A certificate of possession means that you have been granted the land and that you have the ability to make a transfer of that grant to who you would like, provided that they are a member of your nation. Now, the certificates of possession are registered, and they do show up in the Indian Land Registry system. So it's something that can be searched. And some nations have used this in the past, but don't currently. Some have taken a hiatus and are starting to use it again now that banks can no longer try to take advantage of that. And in some cases, certificates of possession have been used throughout. So each nation will handle the possessory interests on their land slightly differently, and that may change with time. There's also things like location tickets. which also apply to lands that have been surveyed. Notices of entitlement are similar to a certificate of possession, and it's registered. However, that's for when land has not yet been surveyed. But many nations use custom land allotments or traditional land holdings in which the nation identifies who is entitled to live on the land, but technically it is owned and held, it's held by the band, which means that if you wanted to gift that in a will, for example, the nation would need to approve that. We move on to the next slide. All right, so wills under the Indian Act. If we move on to the next slide. A will is, as we mentioned in the last presentation, just a document that's assigning an executor to manage and distribute assets or possessions, to pay off the debts, and it can express your funeral wishes. The person that you're assigning is called your executor or trustee. Those words are interchangeable. And it's important to note that wills can be changed as long as somebody has capacity. So sometimes people have multiple versions of the will, and the most recent one, as long as it meets all of the criteria, is the valid one. Now, again, Chris mentioned this already, but these are only effective after death. So it's not interchangeable with a power of attorney per se. Now, I'm really glad to see so many people here today. This is a really important topic to me as a lawyer. I work in community enough to know that this is an area of law that the legal profession has really neglected to provide services for. And I think that comes through in numbers. So, well, it was a couple of years ago, INAC put out a statistic of how many people on reserve pass away without a will, and that was over 91%. We call that an intestacy rate as lawyers, and that is a staggering number compared to Canadians at large. So when you think about why that is, I think that there's a couple of reasons. One is that many nations don't have access to lawyers just based on how remote they are. Another reason is that many nation members believe that the traditional method of expressing what it is that you would want to happen with your estate and with your remains would be respected by family members. However, unfortunately, that's not something that the government recognizes. And more family members may also come to different conclusions about what would be best. And lastly, I think I alluded to this. There's just not a lot of lawyers who know how to do on reserve wills. And it's not that they're complicated, but it's not something that's traditionally been taught in law school. So even for those who do have access to a lawyer, it might not be somebody who feels that they're competent in the area. So it's my hope through my work, and I know Chris feels the same, that we can increase the number of people who do have written wills to avoid the issues that come up without that. As well as to increase the capacity of new graduates and even experienced lawyers to be able to prepare these documents. Can we go to the next slide? So why should you make a will? Well, this is the same whether you're on reserve or off reserve, but I think that it's especially important in small communities. You want to ensure that your wishes are clear to your loved ones. That is especially important when it comes to cherished items that many people might want, as well as your family home. You also want to choose somebody that you trust to carry out your wishes. Without a will, and I'll touch on this later in the slides, but the process is that ISK asks all of the potential heirs who they think is best, and then they would appoint somebody from that recommendation. That might not be the person that you would want to carry out your wishes, though. It might be that you have a child or a trusted friend or neighbor who you think is best suited and knows best what you would want to do that job. It also can really reduce conflict between loved ones about what you would have wanted. And this is a really important thing, I believe, because without this, we do see a lot of fracturing. We see a lot of arguments over family homes, and we see a lot of arguments over what mom or dad might have wanted, whether that's done with their remains or done with a cherished piece of family jewelry. It doesn't matter what the conflict is about. These things do arise, and particularly in those small communities, that can be really, really difficult, not only for your immediate family, but for the community as a whole. And lastly, regardless of how patriotic you might feel, keeping that government involvement to a minimum is always worthwhile. The government doesn't know what you want unless you've put it into a will. And so by doing that, it means that they won't have to be as involved because your wishes are expressed and clear and in writing for people to refer to. Can we go to the next slide? So the process for drafting any advanced planning documents, but including wills, is first to make an appointment. Now, that's not to say that you need to use a lawyer or a notary public in order to do a will. I do tend to recommend that because there is absolutely no substitute for legal advice. But technically, you can do a will yourself as well. I will mention, and it's going to be in the resources, but ISK does have a wills and estates planning. I'm not sure if this will show up. No. It's linked in the resources, a wills, estates, and a planning booklet that takes you through some of the items. However, if you do have minor children or property on reserve, it's really valuable to get some legal advice on what you can do to make sure that your assets or your children are provided for in a way that gives you comfort and peace of mind as well. So once you've made an appointment, you're going to want to think ahead of time about what it is that you want to do, who you want to appoint, who you want to leave things to, what you want done with your body. You might want to talk to family members about it, but ultimately it's really your choice. The more prepared that you are to come to that appointment, the better. And I do often caution people that those appointments can be really, really challenging because the lawyers or notary public is going to ask you a number of questions, not only about your current situation, but also potentially about past situations. So if you have a past spouse, but you aren't divorced, then that's a really important thing that the lawyer needs to ask about. If you're wanting to leave a child out of your documents, if you're not wanting to gift them because you no longer have a relationship, that's also going to be a conversation that the lawyer is going to have to delve into in some detail with you. So it's good to be aware that you may need to have some very sensitive and personal conversations with a lawyer about your life. You're going to give the lawyer instructions, which means telling them what it is that you want from your documents. And if there's something that they can't do, they'll let you know. But by and large, what a lawyer is looking for is getting the information that they need in order to prepare exactly what your wishes are in the proper format. Then you're usually going to have an opportunity to read the drafts. If you don't have an opportunity to review the drafts before you sign, please don't sign them. And make sure that you're asking questions if you don't understand. Wills sometimes include really, really archaic language. Some lawyers in particular like to use it more than others. If you're not sure what it is that it's doing or talking about, make sure that you ask. And then you're going to execute the documents. So your lawyer or notary public will work with you to have the documents signed. Technically, for an on-reserve will, witnesses aren't necessary. However, we do recommend that you have it witnessed by 2 independent witnesses. This really saves time if there's any questions about the validity of the will down the road and your ability to give instructions for capacity. And then lastly, if you're wanting to register the document, Vital Statistics does have a registry. You can register the documents. They don't actually take the original. What they do is they take down the date and the location that you're storing it. So that way your loved ones aren't rifling through your papers while in a state of grief. They're able to locate that document more quickly. Can we move to the next slide? All right, so in order to write a will, you have to be ordinarily resident on reserve. What that means is not necessarily that you're always there. People can still be ordinarily resident on reserve and be away temporarily for school, seasonal work, or medical treatment. You also need to be status under the Indian Act or entitled to be registered and 16 years or older. We'll move to the next. For a will to be voidable, so if somebody wanted to challenge the validity of the will, the arguments that would be made would be that the will writer was under duress, was unduly influenced by somebody else, that they had a lack of capacity, that it's against the public interest, that somebody that they were obliged to provide for wasn't adequately provided for, and that created undue hardship. Or if it disposes of property contrary to the nation or band interests, that can be an argument as well. But I think the most common one that we see is when things are too vague to be carried out. So it's really important that we're being very, very clear with our gifts about what they are. That means that if you're passing a piece of property, you're going to want to give as clear of a description of that as possible. So if there's a CP, then we would normally include the lot number, the CP number, that entire legal description. If it's not CP, then we want to make sure that we're being as detailed as possible about what that piece of property is. Can you go to the next slide? So for a will on reserve to be valid, it needs to be in writing. Oral wills aren't accepted, video wills aren't accepted. So I know that this is a challenge for many, but it does need to be in writing. It's best, as I said, to have it prepared by a lawyer or notary public, but not everybody has access to that. And so many people do use will kits. For example, that is will kit that will be linked at the end. I don't love will kits, and like I mentioned, there's no substitute for legal advice, but in a pinch, it's better to have a will than not to have a will, and to express what your wishes are as clearly as possible. Under the Indian Act, you also need to give something away that you own. That doesn't mean something that somebody else owns. It has to be what you own. Now you can make specific gifts, or you can leave everything in what's called the residue. Now the residue is everything that you own that isn't specifically gifted, and you're going to give that to one or more people in shares. So for example, you might wish to give your cedar hat to your eldest child, but that might be the only specific gift that you want, and then everything else you might want split between your children. It also needs to be signed by the will maker. We do recommend that 2 independent witnesses sign. That means nobody that's named in the document, and they need to be adults. And they only need to see the signing. They don't need to review the will. They need to approve of what it is that you're doing. Now, Capacity and undue influence are things that lawyers are always screening for. And this is important because while they're not technically requirements of the will, they are ways that it could be determined void. So all adults are presumed, as Chris mentioned earlier, to have capacity, but that could be challenged. And we also don't want undue influence or duress. So if you were to have an appointment with a lawyer or notary public, and come in for your appointment and bring a support person that you intended to name in the will, I can't imagine any lawyer or notary public that would not ask you, your accompanying person, to wait outside. Now, why is that important? Because we need to know exactly who is giving us the instructions. That's not to say that you can't bring a support person. It may be that you're not comfortable being alone in a room with a lawyer or notary public and that you want somebody, but it's best when that's somebody that is not potentially going to benefit in any way from the will itself. Can we go to the next slide? We also like to include status. This is especially important for on reserve, on nation land wills. Now, this question came up in the last presentation about if it's necessary. It's not a technical requirement. However, I would say that it is. And the reason for that is that particularly in small communities, there's a number of people with the same or very similar names. And you and your grandfather and your grandson may all have the same name, for example. So by setting out not only what band you are a member of, but also what that number is, it's really going to make sure that they can identify at ISK to validate the will who you are. We also like it when people use the name of the children as it appears on their status card for the same reasons, that it's really clear who those gifts are going to. Because sometimes that's not the same as is on their BCID or what they go by generally in the community. Next slide. Oh, I'll also just mention, because I'm not sure that it's in my slides, that it's really important that you date the will. Again, it's not a technical requirement under the Indian Act, but that way everybody knows which will, if you have multiple, is the last one and when it was that it was done. This can be useful if anybody is questioning your capacity at that point in time, to know exactly when it was done, and to be sure that there's none more recent. Now, I wanted to touch on who you should choose as an executor or trustee. This is no different than for off reserve. You want to choose somebody that you trust, who understands, respects your values, wishes, and beliefs. This is so, so important. This is a person who is going to be holding all of your assets to distribute, to pay off your debts, and to give your gifts and arrange for what you want done with your remains. And so having somebody that really understands you and what it is that you would want can go deeper than just the words of the will. It's also important to have somebody that's generally good at record keeping. It's a lot of paperwork to do these jobs. And so that's going to be really, really helpful as well for them. You also want somebody who understands the responsibilities. So if there's someone who's not so great with money, while they're holding all of that money temporarily, you don't want them to be in a situation where perhaps they have one of their own bills and they borrow from the estate temporarily. So it's a really good idea to choose somebody who's quite responsible themselves with how they handle their money. We go to the next slide. So the reason that I covered off land in the first place is because giving land in an on-reserve will is really dependent on what type of possessory interest that you have. So for a certificate of possession, that gift is going to be binding. If you want to leave the home to say your nephew, because your nephew's been living with you, has been taking care of you. You're going to want to make it a very clear gift that you're giving your certificate of possession to your nephew. And that gift has to be honored. There's no way around it. Technically, the minister must approve of any possession of reserve land, but that's a binding gift. Now, if you don't have a certificate of possession, perhaps you haven't paid off the mortgage in full yet, or perhaps you live on a nation lands where the nation doesn't use certificates of possession. You can still identify the gift of your land in your will. However, it's important to note that that is going to be an expression of your wishes, and ultimately it's going to be up to chief and council to honor those wishes. My experience in community is that those wishes are more often than not honored, but there could be a foreseeable reason why they really need to provide that to somebody else. And so keep in mind that that gift is not necessarily binding on the nation if there's no certificate of possession. I'm also going to note that you cannot create a trust in the will for land. So some people want to do that for minor children. You can leave the land to a minor, however, which is something that you cannot do off reserve. So that's kind of an interesting difference. Let me go to the next slide. So if you don't have a certificate of possession, like I mentioned, you can still absolutely express your wishes, and I often encourage people to do this. Ultimately, it is up to the nation or band to determine who can hold the land. I'll also comment that if you built your home on that lot, you may still have an ownership interest in the building, even if not the land. So that the value of that, even though you may not be able to give it as it is, the value of that might be something that could be paid out as a gift. Next slide. So there also are some assets that transfer outside of an estate, and I went over this a bit in our presentation on Tuesday, so I won't go too deep into this, but any assets held, sorry for that typo, in joint ownership. Many CPs are held in joint tenancy, some are not. So if you inherited a certificate of possession from a parent along with your siblings, the odds are that it's held in, sorry, I've got a bit of a cold, that it's held in what's called tenancy in common, which means that you each have a share. So if the wording of the CP is that you have a 1/3 interest, then your tenant's in common and you have the ability to leave that as a gift. But if it's held in joint tenancy, say with your spouse or with a child, then that is going to transfer, your interest in that will transfer directly. So it's really important to be sure about how you want to leave gifts, but also what your interest is. And with a CP, a lawyer can help you by looking at those documents. Similarly, life insurance policies, investments, and pensions, you can appoint beneficiaries, and those will travel outside of the estate as well. Move to the next slide. So I'll just touch briefly on what if you have minor children. Now, I work for a seniors focused organization, so I don't often deal with clients who do have minor children, but it does happen. So you can appoint a testamentary guardian. You can do that on or off reserve. You're welcome to name whoever you want to be a guardian. But it's important to note that family law in BC will likely override your wish if it doesn't align with the law. So if the other parent or guardian is fit to take on those parenting responsibilities, and it requires quite a substantial reason to not give them the parenting responsibilities, then ultimately who you've appointed as a guardian is not going to really affect where your minor children goes to live. Similarly, I mentioned that you can leave land to a minor on reserve if you have CP. And your money and possessions can also be given to them, but a minor cannot sell or lease CP land without an appointed guardian. Aboriginal Affairs is the department that you would work with to appoint a guardian for their interests. And then we can create trusts for minor children, but it only is with respect to off-nation or off-reserve properties. So for example, if there's money in a bank account, that's likely going to be held off-reserve. And you might want to create a trust for your child for that, because I do often caution clients that minors coming into large sums of money can be absolutely devastating to their future. Move to the next slide. So if you wanted to change your will, you're welcome to do so as long as you have capacity. We do recommend that people review their will every time that there's a major change in their life. Now, some lawyers will tell you that you should look at it every year. Some lawyers will tell you you should look at it every 5 years. My view is that what you wished for 20 years ago may still reflect exactly what you want. But if there's been a big change, if you've gone through a separation, if you've had children, if you've lost children, if you've come in and won the lottery, and I wish that for all of you, those are really good times to take a step back and say, I better check to make sure that it still reflects what I want. And if it doesn't, I should update it. Whatever the most recent valid will is the one that is going to apply. There are circumstances where one will was written 10 years ago and that one gets sent into ISK first, and then another will is found later that was more recent. It's really important that if you find yourself in situations like that as a family member, that you're updating ISK as soon as possible, that there's in fact a more recent will. Sorry, I just moved into the administration side of things. And the best practice is to draft a new will. There are codicils, which are an old way of making changes back from the typewriter days when it was more work to type up a new will than to do a codicil, but that's no longer the case with computers and printers. So please just do a new will. Codicils can invalidate old wills. They can cause all sorts of confusion. It's not worth the trouble. We move to the next slide. So for administering wills under the Indian Act, because this is a question that comes up fairly often, the first thing that happens when somebody passes away is that Indigenous Services Canada should be notified, and they're going to ask for basic information about who the person is and where they live to determine if they have authority over the estate. And they will give some, I say advice, but information about what the next steps are going to be. If there is a will, then you're going to want to send that will in to ISK along with the death certificate. And the death certificates can be obtained from Vital Statistics. And at that point, ISK is going to review that will and determine whether or not they view it to be valid. So it's got to meet those criteria of being signed, being somebody who lives ordinarily on reserve. And then they will appoint the administrator or executor, depending on if it's valid. They will authorize the executor. Pardon me. Then the executor's role is to kind of gather all of the assets, pay off the debts, do final taxes if there's taxes to be done, identify all of the heirs, and distribute the gifts, and make any funeral arrangements for your remains. And once all of that is done, there is a requirement that there's a final accounting that's submitted to all heirs. and to ISK if they request it. So you should keep those documents for 7 years, so that if there's any questions that come up about what you did with the estate assets, you're able to answer those. We go to the next slide. All right, so as I mentioned, over 91% of people on reserve are passing away without wills. So what happens with that situation where somebody dies intestate? Well, there's an order of inheritance. So it goes kind of in order of proximity to the person. So a spouse, which could include a legal, common law, or same-sex spouse, gets everything if there's no children, or the first 75,000 if there are children, with the remainder going to the children in equal shares. If there's no spouse, then everything goes to the surviving children. That includes both biological and legally adopted children in equal shares. And if the deceased left, I think my slide has a typo in it. If the deceased left a share to a child that predeceased them, but they have children, then those grandchildren will get their parents' share in equal shares. If there's no spouse or children, then the estate goes to parents. And if there's no spouse, children, or parents that are surviving, then it goes to surviving siblings in equal shares. If a deceased sibling, if one of the siblings is deceased and left surviving children, then they'll get their parent share in equal shares, but that does not apply to interest in CP land. So that's an important note. It's not super clear in the legislation, but the court has determined that nieces and nephews are too distant without a will to inherit CP land. And the same goes if there's no brothers or sisters and nobody else, then we'll look for the next of kin. But again, that won't apply to the CP land. That land interest will revert back to the nation. Can we go to the next slide? Now, I promised to touch on the matrimonial real property rights. This is a very, very complicated act in my view. Some people are more comfortable with it. There are many guides out there available on how to navigate it, but I think that it really comes down to your specific fact situation. So if you find yourself, or somebody that you know finds himself in a situation where their spouse has passed away on reserve, then I would encourage you to seek some legal advice on what they might be entitled to. Now, this act was intended to address gaps in family law on reserve. So it has provisions for both protection orders and some family violence situations. But more pressing for the purposes of our presentation today is that it allows for occupancy not only during the relationship and separation, but also after death. So if somebody is non-status or non-member of that band, they cannot inherit land on reserve. That's an absolute. In order to inherit that land, you have to be a member of that nation. So this protects, this will protect spouses who are living in the home. Say that you married somebody from another nation, they did not change their membership to your nation at the time of marriage. They kept their original membership to their own, and they've been living in that house for 30 years. It's their home. They raised children in it. Well, you don't want your spouse, just because they can't inherit the land, being booted out. Can we go to the next slide? So it provides that a surviving spouse can stay for up to 180 days or longer with a court order. In particular, if somebody's wanting to stay longer, having minor children is a very, very compelling reason for that. If a surviving spouse doesn't have an interest in the home and isn't given one in the will, then they can also apply to get a share of the value of the property, but you're supposed to apply within 10 months from the date of death. And only a member of a First Nation can have the property actually transferred to them. Like I said, in order to inherit, you have to be a member of that nation. Now, that's not to say that somebody who's not a member of that nation doesn't have an interest in the home. It means that they will be bought out for a number that the court determines is suitable based on the value of the home, because they cannot actually have ownership on nation lands when they are not a member. I know that this probably is very confusing. So like I said, if you find yourself in this situation, please seek some legal advice on it. Can we go to the next slide? All right, so I will pass it over to Chris to do a final summary of the different documents.
Thanks so much, Catherine. And I just wanted to repeat for everyone in the chat that unfortunately, it's not going to be possible for us to answer all the questions in the chat. There are frankly way too many. And also, for the benefit of the recording, any answers we provide in the chat won't be made available to anyone else. I was trying to monitor and pick out any general questions I thought I could answer. And so, like I said, for the benefit of the recording, I wanted to try to provide those answers just orally, I guess. I noticed there were some questions about what the difference between joint ownership and in common or tenancy in common or joint ownership. Joint ownership means equal ownership, and that's where the right of survivorship, or where one person passes away, the person who's joint owner automatically gets to own it because they equally own it. And in common ownership refers to when you only have like a 50% if it's two people in common. And I also think I saw a question about intestacy, and I think Catherine made this point, but sorry if it wasn't clear enough. Intestacy refers to when someone does not have a will. So if you don't have a will, that means intestacy. I think I also saw a question about resources for people in Vancouver or the greater Vancouver area. A clinic I used to work at, the Indigenous Community Legal Clinic, run through UBC, which is in the downtown east side of Vancouver. I haven't been working there for a little while, so I don't know their exact practice areas perfectly anymore. But when I was there, we were helping people with wills for folks on reserve. Yeah, I think, and frankly, almost all the other questions I saw, it just depends. I can't, and we won't be able to answer them. I wouldn't even be able to answer them adequately in the chat if I had the time. And so unfortunately, I might ask you to, for all those kind of other questions, to maybe reach out to some of the service providers. And you know, like at my clinic, for example, you could come and meet, have an appointment with us where all you do is ask us questions, and we'll on the spot, frankly, but we'd write them all down and then provide detailed answers. And I know many of the other clinics would be able to do so as well that we reference. So yeah, again, I apologize that we're not able to do more. I wish we could, you know, spend a whole day answering all the questions in the chat. We've did our best to cover everything in this presentation, and I apologize that we're not able to do more. So with that said, I guess, I just want to try to briefly summarize the different advanced planning options we've talked about today. Of course, the majority of today has been spent talking about wills, and those, again, are only effective after death. They must be in writing and signed. And the purpose of that document is to pick someone to handle your stuff in the way you wanted it to be handled, and tells the people how you want it all to be handled. Power of attorney, representation agreements, and advance directives are all documents that apply when you're alive. And for more detailed information about all of those, please check out part 1 of our presentation. A power of attorney is, as I said, only effective when you're alive. All of these documents must be signed and in writing. And a power of attorney document picks someone to handle your legal and financial affairs, and it can be limited or broad. A representation agreement, also effective when you're alive, must be signed in writing, but it's more about health care and personal care matters. And then finally, an advance directive, also effective when you're alive and must be in writing and signed, but it's really a message directly to healthcare providers about procedures that you do or do not consent to. And so the next slides we have are for some of the resources that I hope you can actually reach out to be able to answer some of those questions that I've seen in the chat that I'm not able to answer. And again, I apologize. So Seniors First, the organization that Catherine works for Indigenous folks, they help people over the age of 45. And I think I also saw in the chat like a question about those, you know, what help is there for people who are maybe younger than that? The Law Center is able to draft wills for people no matter what their age. We do have an income test though, so we do only help people who are on the lower spectrum of the income side of things. And you can only make appointments with us currently by calling in. I'm working on trying to make it easier to get appointments with us, as well as we're doing intakes at the Victoria Native Friendship Center. As Catherine said, there's a real knowledge in the legal community about how to help Indigenous folks write wills and manage their estates. But Catherine and I are taking that on very seriously. We're trying to create entire generations of lawyers who know this through my work at the Law Center. I work with about 45 students every year go through our clinic. And Catherine's been so generous and kind in helping us train every student who's going through the Law Center now to be able to be qualified to help write wills for Indigenous folks on reserve and with status. So we're hoping that this will change in the future. We're taking it on very seriously and doing, you know, as much as we can to make those improvements. The next slide has more resources, including the Law Students Legal Advice Program, a clinic I used to work for. It's a fully student-run legal clinic. My program uses students, but it is still run by lawyers such as myself. And I should put a bit of a caution when you're working with law student organizations that everything takes a little bit longer when you're dealing with a law school student. And so that slide that talked about the process of drafting these advanced planning documents, I'd say that process takes a little bit longer. It's a bit of a longer journey when you're dealing with law school students. One reason is they kind of need to double check everything. They're a little bit more unsure of what to do and need kind of to meet with lawyers usually before they can take any steps. It also is a fact, like right now, we're currently actually in between terms as law school students have just kind of finished their exams and we haven't quite started the next semester. And so for LSLAP and the Law Center, for the Law Students Legal Advice Program and the Law Center, there's a few periods during the year when our services are very limited and it's very hard to frankly even just manage the files we currently have when we're in between student groups. So just I ask you to be a little bit extra patient when you're working with law school students. And I know it can be a real kind of unfortunate circumstance of kind of passing ships in the night when we have at my student clinics, you know, clients who are ready to give us instructions. But unfortunately, that happens at a time when we're really short-staffed and have very low resources as we might be in between terms. So just be a little bit extra patient. Through the Access Pro Bono's lawyer referral service, I do just want to explain that referral, that resource a little bit, because it's actually a bit of a two-step process where you contact Access Pro Bono's lawyer referral service. They'll give you the name and contact information of a lawyer who practices in the area you ask them for. So you could ask for wills and estates for folks on reserve or off reserve, whatever applies to your circumstance. Then they'll give you the name of a lawyer in your geographic area, which is also helpful. and then you can contact that lawyer and get an appointment. Only 15 minutes. I recognize that's really not enough. Hopefully with our presentation, that might help you get a lot more out of that 15-minute presentation or meeting. But if you don't like the lawyer who you meet in through the lawyer referral service, contact them again and get the name of another lawyer. You can use the lawyer referral service over and over again to find a lawyer who you trust and respect and want to work with. I often tell people that finding the right lawyer for you is a lot like finding a good counselor. It probably and may not be the first person you talk to and interact with. You got to develop a real good relationship, a trusting relationship with that person. And then there's also some online resources on the next slide. Yeah, those can be helpful, although not always going to kind of answer all the questions. I kind of agree with Catherine that there really is no substitute for legal advice, and sitting down with someone to be able to really answer your questions pointedly to your exact circumstance. As I train law school students, part of my training is frankly that as we get out in the world, we get very used to having people ask us kind of random legal questions, and it almost always depends on a million little details that can only really get pulled out through a more longer relationship, a very specific one-on-one meeting. So kind of it depends is what I frankly train students to kind of have to say. Unfortunately, also, when it comes to legal advice, I think there's a tendency to kind of, oh, I'm not really too sure about that answer, but I really want to help this person, so I'm going to try to come up with an answer. But tragically, with legal advice, wrong legal advice can lead to making decisions and steps that cannot be undone. And so, unfortunately, no legal advice is actually better than wrong legal advice. So, I also apologize that we're not always able to provide answers as it always sometimes kind of comes down to all the minutia and detail. Great. Well, thank you all for taking time out of what's very busy and going through what is very, difficult material and complicated material. So thank you all for taking the time and meeting with us all. Apologize that we're not able to give as much help and answers as we wish we could.
Wojcika, Chris, and Catherine, really appreciate all the information that you shared today, and just really appreciate the complexity and the depth of this information and the care in which you shared this information with us. So I will pass it over to Wichtal if he's to close us off in a good way. He's on his way, looks like, to a meeting, and then I'll share a few more closing words after that.
Ocean, thank you, Tieltawit and Stomo, giving thanks to everyone for being here. I'm actually just on a slow parade pace going through Kamkamalai, also known as Vancouver. I want to lift my hands up to all of you in gratefulness and thankfulness for witnessing this beautiful work on behalf of all of our presenters. Most of all, for your kindness and patience and sending good positive energy your way. Just going to beg off a bit early here. Just the light's going to change green, so I'll be safe and you be safe and take care of one another out there. Wojciech,
Wojcika, thank you so much. It's wonderful to have Wichtal here today to open and close us in a good way and ground us around this Very important conversation. I know folks have been asking in the chat, all the information and slides and video will be available afterwards. Just want to thank you all for being here today, and remember to please sign up for our newsletter to learn of any upcoming sessions. Not sure, Cynthia, if we're going to show the slide of the upcoming webinars. Here we go. So we've got some upcoming webinars that you can find on our website. They're all free to sign up for. And you can see the website there, as well as the link in the chat. So again, Hoichka, thank you all for being here today.